So due to the negligent act, this ship caught fire and burnt. So owners filed a case against Remoteness. So the Privy Council decided definitely this is the negligent act and test of directness they have applied. Normally when you load benzene, which is highly volatile, when you load petrol, when you load till, you should have been more careful. You cannot say that your servants acted in a negligent manner. So test of reasonable foresight has gone, test of directness was applied, and the owners were given compensation by the chartered man who chartered this Remoteness. Right. The second example is test of reasonable foresight. The best example is called as wagon mound case. Wagon mound case. This case actually this wagon mound, you please, case law is Overseas Tank Ship Co. Limited. Overseas Tank Ship Co. Limited versus Marts Marts Dock and Engineering Co. 1961. Right. Here the overseas tank ship, these have got so many ships. One of the ships is called as wagon mound. This wagon mound was taking bunker oil. Actually it was taking fuel in Sydney Harbour, Australia, Sydney Harbour. It was taking the oil, but due to the negligent act of the workers, somehow the oil spilled. While loading, normally the oil go out. So the oil spilled and it has travelled up to a distance of about 600 feet and it has clearly caught an eye. మనకి తెట్టు అంటాం, తెట్టులాగా ఫామ్ అయింది. It mixed with the sea water, right? So about maybe around 600 feet or so, there was another workshop in that dockyard. మీకు తెలిసిన డాక్ యార్డ్ అంటే షిప్పుల్లో ఇదొక డాక్ యార్డ్, అదొక డాక్ యార్డ్, ప్లాట్ఫామ్స్ లాగా ఉంటాయి. సెకండ్ ప్లాట్ఫామ్లో ఇట్ ఈస్ ఓన్లీ దిస్ వర్క్షాప్. సో దే వర్ రిపేరింగ్ 2 or 3 ships there, right? Actually these people stopped the work of the welding work is going on in that Marts Docks and Engineering Co. So because the oil leaked, then they somehow thought that maybe some trouble, therefore they did not do it, they did not do any work. After 3 days, the concerned engineer or people came there and they said, okay, since the oil has leaked and everything is okay, so now you can continue the operation. Now the welding operation started in the Marts Dock Engineering and Co. Please remember, previously from the other wharf or from the other platform, from that wagon mount case, some oil has leaked and it has mixed with the sea water. తెట్టులాగా అక్కడే ఉంది. But these people dared and they started welding operations. So welding operation means oxyacetylene gas will be there. Somehow the sparks fell on a flannel cloth which was floating on the sea water. Because underneath there is oil, it caught fire and damaged almost. It has moved the 2 ships present in the Marts Dock and Engineering Co. Finish. 2 ships were gone. So they have filed a case. Ultimately the overseas tank ship Co. they have to pay compensation. The council decided that. So definitely these people should have taken precautions since they have exhibited negligence. So test of directness applied and these people were asked to pay compensation. Now they have gone in appeal before the Privy Council. Who? Wagon mount, overseas tank ship, they have gone in appeal before the Privy Council. Privy Council applied the test of reasonable foresight because, right, okay, the oil leaked. It mixed with the sea water. The other people, they did not foresee. They thinking that due to the leakage something may happen. They stopped the work for 2 days. After that only they started. That means they are confident that nothing will be done. So test of reasonable foresight is there. Therefore the appellants, that means wagon mound people, they need not pay compensation. This was decided and this is the best example for the so-called test of reasonableness, test of reasonable foresight. So these are the things relating to remoteness of damage. Definitely you will get a question. Please read the subject thoroughly, and these 2 cases are more important: Remoteness and wagon mound. Thank you.